I thought we were done with renewal options on right before lunch, but it turns out we have about another 5 slides or so, we had a break at an inopportune time. So we're going to continue on the subject of renewal options. And if you remember when last we visited with our brave procurement officers, we found out they had just lost in the Baltimore County Circuit Court because they had not given an absolute unequivocal notification that they intended to exercise a renewal option. So they lost the availability of the renewal option. So this was just continuing on what the court ruled in that particular case. And the court ruled that notices that only indicated indecision did not matter, i.e. we're still thinking about it, isn't good enough. That does not preserve the right to give an absolute renewal notice after the expiration date. So even if you put them on notice, or even if you seek to reserve the right to give them the notice after the expiration date, it doesn't matter. If you did not give them the final absolute notice before the current contract term has expired, then the renewal has expired and you do not have the legal authority to exercise it. And again, like I said this morning, although this was a decision involving Baltimore County, not a state agency, the precedent is presumed to be valid for all public contracts in Maryland, since this is one of only 2 known. There might be other ones, but our attorneys have only found this and one other one on this topic, and so you have to follow the only precedents there are. Let's see. So a contractor that does not want to perform for an option period is free to stop performing once the current contract period expires. If the contract has expired, they can stop. Subject to a possible unilateral order by the procurement officer for the contract to continue working. And this is the thing that we're not sure whether you legally have the authority to do. So if you think you want to do this, you need to go to your lawyers to see whether they will back you when trying to order the contractor to continue to perform. What is generally permissible is this second one. That is not something that is in doubt. It also might be permissible if both parties agree to a modification to extend the current contract in lieu of the renewal option. And the reason why we say probably is you generally need additional approvals, depending upon the value of the option. If it's more than $50,000, it has to go to the Board of Public Works. If it's less than $50,000, I guess you can do it here, right? We have delegated DHMH $100,000 of authority, and that's $100,000, and the way my technical terminology is no matter how you slice or dice it. So if you have done a $90,000 procurement, and you've approved that in-house at DHMH, then you only have $10,000 of additional authority to do anything with that $90,000 award. So you could do a $9,000 modification, but you could not do an $11,000 modification. Conversely, if it was a $40,000 award, you could do a $40,000 renewal and a $10,000 modification, etc. Anything that keeps below $100,000. And if you took an item to the Board of Public Works, if you had a $1 million contract, that because it exceeded your authority, you went to the Board of Public Works, you still have $100,000 of authority for options or modifications, as long as no single modification exceeded $50,000, because the board says it wants to see anything of more than $50,000. So that's why we say that this thing, for an extension, depending on the dollar value, may need Board of Public Works approval. Let's see. All of which means you should pay attention, you must pay attention, must, shall, will. Shall. We have a vote for shall. You shall pay attention to renewal dates and ensure a firm renewal notice is issued before an option expires. Any advanced approvals that are needed to exercise an option shall be obtained. It's permissive, however you want it, must or shall. Should be obtained in time to give a firm renewal notice before the expiration date. It's kind of unlikely that you would need to declare an emergency if you did not have this in place, but it kind of depends also on what the contract is that you're coming up on a renewal option for. And if you think that It will be detrimental, extremely detrimental to the agency, to clients, to residents, etc. if something is permitted to expire. Maybe you have the wherewithal to declare an emergency, but I want to emphasize this other point. Should only be done after consultation with the Office of the Attorney General and any involved control agency. You don't want to do something on your own that you have to report to the Board of Public Works only for them to say, why did you do this? Why did you think you needed to do this? And they will not so much say that to you, but they will more than likely say that to someone named John Colmers or Sherry Wilson. People of that nature will hear it more directly than probably you. Let's see. That's the next one. It may be advisable to seek some, here's where Gary had mentioned this. It may be advisable to seek some inducement for an agency to exercise a renewal option. And that is what is supposed to happen. You're not supposed to automatically simply exercise renewal options. You're supposed to actually examine what you are getting, examine the performance of the vendor, examine the price, supposedly make some kind of determination of how good that price is relative to what you think you could get in the marketplace if you would do a new procurement. And that is supposed to be the factors you look at to decide whether you want to exercise a renewal option. And so let's say you're teetering on the fence. So do I want to exercise? Do I not want to exercise? And as Gary has mentioned, you can perhaps casually, perhaps not so casually, mention to the vendor, to the contract manager for the vendor, you know, we have this renewal option coming up and I just can't decide whether we want to exercise that because we think we might be able to get a better deal if we go out in the procurement. And so I'm thinking that that's probably the way we want to go. And the person may ask you, well, what can we do to help cement your decision to exercise the renewal option? Well, taking some money off the table will certainly help with the decision. And even if they don't offer it, as Gary said, one of the things that agencies have been kind of directed to do is to seek reductions from vendors as an inducement to exercise renewal options. You cannot strong arm them. You cannot say, you give me a 20% reduction or else, at least not that it's on record. But you can invite them to make an inducement to you. Yes?
How far in advance should the agencies take these steps?
Well, going to a vendor, the question is how far in advance should you be contacting your vendor to find out about whether they're going to give you a better price or any kind of incentive for you to exercise the renewal option. And if you look at leverage and the issue of who has the upper hand, if you go to them, let's say 30 days before the existing contract is going to expire, when everybody knows it's going to take you 4 to 6 months to do a new procurement, and 4 to 6 months to do a procurement, 30 days left. Can I do a new procurement? No. So is there a whole lot of leverage with you going to the vendor and saying, if you don't give me a lower price, I'm not going to renew? And the answer is no, because the vendor knows you have no alternative but to renew. So maybe they'll give you a few bucks off or something, and maybe they won't. Conversely, if you go like 6 months in advance, when you definitely do have time to do a new procurement, and ask them, that can help make the decision as to whether you do a new procurement. Because you can do a procurement while you still have a renewal option, and then not award under that procurement if the renewal option is better than what you would get from vendors under the procurement. Conversely, if you get better deals, you simply award the new contract and you don't exercise the renewal option. So that's something you can do. And I think we described that more in the Perform class. Again, we describe a lot in Perform class. But it only has value as a leverage over the vendor if you do it with sufficient time to actually pull it off.
Question.
Yes?
You go to the vendor and the vendor says, I'm willing to give you a 10% reduction. What happens next?
What happens next?
Document all of that.
What happens next is right there. Any change in the terms of a renewal option must be done as a modification to the renewal. The renewal has been negotiated in advance before the award was made. You only have the right to exercise the renewal option or not exercise the renewal option. If you want to make a change, you must negotiate a modification. You must have the modification approved at whatever level is necessary so that the modification takes place simultaneously with the renewal. So you're renewing under the same terms and conditions, and then you will have a trigger. You will have a modification that says, upon approval of the renewal option, these terms and conditions will apply. Reduced rate, whatever else you're going to get. So you're exercising the option as is and doing a modification. You can't just exercise the renewal under different terms than the renewal is. Has to be a modification. And you need to go to your attorney to get the words of the modification so that it's clear that it is basically a simultaneous situation and the one is in exchange for the other. And a question I thought you might perhaps were going to ask is, what if the vendor says, I'll give you a 10% reduction, but you have to exercise, let's say, both renewal options. If you have two available renewal options, a vendor can come to you and say, I'll give you this deal if you exercise both of them. Can you do it? Yes, you can. If you think that is in the best interest of the state, and if that renewal with both options is more than $200,000, you're going to go to the Board of Public Works, and you're going to tell them why you're asking them to approve two options simultaneously. And the answer is going to be because we're getting this deal as an incentive for us to do it. And if you can make the case of why that's in the best interest of the state, we can do it. Let's see. Is it okay? It is okay for an agency to invite a contractor to make a better offer. You cannot extort. Modification, simultaneous. Okay, I've said all that. Okay, so I guess that finishes the topic on options. So any questions on options? Now we're going into something oh so exciting. If you thought what we've done so far is exciting, wait till you get to this section. Amen. Solicitation structure. It is advisable to have clearly delineated sections of a solicitation. In particular, it helps vendors focus on what is to be done so they don't miss anything. And a corollary, anything that helps vendors indirectly helps us. If it helps them understand things, it helps us. The less problem, less confusion, less protest, less everything. But it also helps the state because it allows an easier focus for contract management. And that's something I'm advocating. You always look at how do you manage the resulting contract. And if you structure it in such a way to not only identify how you're going to manage, but in ways that makes it easier to manage, then it's better. And I'm going to submit to you that structuring the solicitation in the manner in which I'm going to explain the next 20 minutes, half hour, whatever, does to some degree help in clarity with vendors, management of contracts after award, etc. And because the reason is because if you structure it the way I advocate, there's only one place anybody has to look in the solicitation or the contract to find out what the vendor is to do. And one of I'll explain the situation that occurred years ago, because I can remember when you would have to virtually read the entire document to find every place that there was a requirement for the vendor to do something. There might be something on page 1, something on page 5, something on page 20, something on page 50, and you basically had to go through and read everything to get all the requirements. And I can remember in 2001, with the PBIS procurement that was identified a couple days ago, the one that we actually never awarded, I can remember, because there were so many deliverables from the vendor, at one point I went through every section of the solicitation, page by page, and listed every deliverable. And I would say, literally, page 2, section 8, page 3, section 10. And I took probably a couple hours to go through and specifically identify everything, jot it down, put it in the computer and everything, and then a light bulb went off in my head. And that's why I have the problems I have today. That's a joke. That now that I've gone to all the effort to identify all the sections that have deliverables that the vendor is to do, wouldn't it be simpler to take all those spread out over 20 or 30 pages and put them all in one section? And that at the time was a revolutionary concept. So revolutionary that I went to my assistant AG and said, gee, I have this thought. This sounds like this would be something worth doing. What do you think about it? And the answer was, I don't think we need to do that. But within a year, we were doing that, because it's something that just kind of grows on you. If everything is in one place, everyone knows there's one place to look for deliverables. You know, the contract manager knows, the vendors knows. No place else for it to get lost. And the very fact that you have it segmented in that manner means you're specifically going to focus on every aspect and make a determination, is this a deliverable? If it is, I know where I'm going to put it. If it's not a deliverable, I know I'm going to put it somewhere else. Just seems simple after the fact. Let's see, whatever. Design section. So I've said that. Separating clauses by sections causes the agency to decide if each clause really is a work requirement versus administrative detail, boilerplate, or one of those things that you're not supposed to have, unnecessary verbiage that doesn't add anything. Because if it isn't required, if it isn't deliverable, if no one can figure out what it is, it probably is a good candidate to just take it out and eliminate it. Structuring the solicitation in the manner I'm talking about is generally more important for a sealed proposal procurement because there are more elements in a sealed proposal procurement. In a sealed bid, you have fewer details, fewer elements, and it's a lot easier to just have what the vendor is to do and then the price. But it makes more sense in a sealed proposal environment. But it's also helpful in sealed bidding as well. So here's the general recommendation. And again, you can see that some of the focus is more on sealed proposals, but general recommendation. You start off, and this is how you structure your solicitation. Number 1, title. This is a request for proposal, an invitation for bid for the provision of food services at the Thomas B. Finan Center, et cetera, et cetera. So the title page tells you state agency, the particular facility, what it is, an IFB, an RFP, the subject matter, et cetera, all on the title page. Key information, even though it's self-explanatory, I just explained what the title page was. Key information summary page. That's a general page that goes over, and actually, I probably don't need to tell you this right now because I have these described on slides, so I probably should wait till I get to the slides. Here's just the general structure that we recommend. Title, key information, notice to contractor, table of contents, summary statement, definitions, administrative detail, minimum vendor requirements, scope of work, basis for award, boilerplate, and attachments. And now we're going to start going through these. I've already said what the title page is, even though it's unnecessary to say what the title page is. Key information summary page, typically a one-page, at-a-glance summary of the core essential information of the procurement, such as the title and issue date, the date, time, and location of the pre-bid, pre-proposal conference, site visit information, due date, time, date, location, Contract start date, duration, option period, MBE goal, maybe some other information. So right at a glance, typically on the second page, so someone, a vendor who gets this and looks number one at the first page and then number two at the second page, has a lot of information right there as to tell them what it is that's being done and when timeframes are. And I can remember when this used to be buried perhaps 20 pages into the document. So a vendor would have to go page after page after page to just find out, well, when's the pre-bid, when's the due date, etc. So this makes it a lot easier for them to focus. So we recommend, and this is a general recommendation. Summary statement, purpose. A few paragraphs, a high-level explanation of the overall reason or purpose for the procurement and the contract to result therefrom. Why are you doing it? To achieve world peace, to end world hunger. That's kind of like the high overarching purpose.
Wouldn't that be similar to the scope of the work?
No.
You're making it different than the scope of the work.
This is just a general high-level overview. It's not going into any detail. It just says, this is what I want to have done or accomplish. And generally, this is like one paragraph or so, and it can be a short paragraph. Or at the most I've ever seen is maybe 2 or 3 paragraphs, because that's what you're doing. You're giving them high-level overview, the proverbial 10,000-foot view of the procurement. And typically, you will then go into the next part here, the background. So in the first one, you said what you want to achieve, and here you're giving the background of why are we doing it? How did we get here? Stuff that maybe the vendor doesn't have to know to respond, but it's kind of like a nicety to help set the stage for what you're going to ask for hereafter. Also relatively short. Administrative detail. This is my terminology because I started trying to think of how do I identify these different aspects, and I just came up with, I called it administrative detail. So you can call it administrative detail, you can call it whatever you want to call it. But I'm going to describe it in the context of administrative detail, which you probably won't see anywhere else. If it is, it's coincidence.
Would that fall under the category of general requirements? I've seen
Well,
that used sometimes.
we're going to get into what I mean by that. Is not common terminology. It doesn't matter what you call it. What is important is the description and distinction from the other solicitation sections so that proper placement can occur. And I identify 3 types of administrative detail: generic, pre-award, and post-award. And obviously, some pertain before there's award, some pertain after there's award, and some going to be common and exactly the same from procurement to procurement. All right, let's see. Generic detail. This is comprised of clauses that typically are exactly the same for every procurement. You're not going to customize them. You're just going to have as your standard boilerplate, your standard template, that these clauses are going to be in there. And some examples. You have the right to award in whole or in part. And you'll probably say, yeah, I remember reading that over each solicitation. You're going to see the department reserves the right to make awards in whole or in part. And you never customize that because it's always the same language. You're going to have a section on vendors' ability to ask questions. And you just say you can ask questions of the procurement officer, preferably by email, et cetera, et cetera. And I say this is considered generic since we do not recommend that you have a question cutoff date. That is not a recommendation, and I will deal with that later on. But if you don't have a cutoff date, you can have one generic clause that you can use in all solicitations. Registration on email to marketplace. In order to receive a contract award, vendor must be registered in email to marketplace. Registration is free. To register, go to www.dgs. Same clause is going to be on virtually any solicitation. You will not be responsible for vendors' incurred expenses in submitting a bid or proposal. That's generic language. You have the right to amend the specifications There's a number of clauses that you just put in there because you know you're supposed to, and they will not vary from procurement to procurement. Just continuing examples, if a potential attendee at a pre-bid, pre-proposal conference needs special accommodations, they should provide at least 5 days notification to the agency, and we will make reasonable efforts to accommodate such requests. We will have generic language that says, we will not accept a late bid except under the circumstances described in 2105-0210. And it's going to be there, and it's never going to be different from procurement to procurement. Reciprocal preference language is always going to be the same from procurement to procurement. So generic detail might also be considered as boilerplate language, except it only applies in the procure stage. And up until there's an award, and after there's an award, it's like it disappears. It's like the initial booster stage of a rocket. It gets it into orbit, and then it falls off, goes away, and it's like it was never there. So that's what I call generic administrative detail. Now, pre-award detail. What this means is this is very important information before there's an award. Once there's an award, again, it evaporates as if it never was there. And by giving some of these examples, you can see what I mean. Specific necessary detail customized for each procurement. While this information is essential prior to an award, it is unnecessary after an award. For instance, the number of contracts to be awarded. Well, that's important to know how many awards you're going to make, but once you've made the awards, then, well, you've already made them. So it isn't an issue of how many you were going to, could have, it's how many you made. The procurement method, you're going to make the award by competitive sealed bidding, competitive sealed proposal, multi-step sealed bidding, whatever it is. That is very important up to the point of award. Once you make the award, then it's already happened. You don't need to worry about that any further. Pre-bid proposal conference information. You think about this: when, where, what date, what time, what location is the pre-bid, pre-proposal conference. Very important. But after an award, do you need to worry about any more? Where was the pre-bid conference, or when was it? The answer is no. Response information, the due date, time, and place. Extremely important up until an award. If they didn't submit, they're not going to get an award. Once there's an award, well, they've already done this. So this language has no further effect in the contract. Let's see, what information has to go in the outside envelope, etc. Which attachments must be returned by the selected vendor after the selection versus all vendors. So you're telling them what they have to provide to you. After an award, then that generally doesn't matter anymore. Things like federal funding acknowledgement, which is something that you require here if there's federal funding, because the feds require that you acknowledge that they gave you money. And so in situations where there's a linkage between an award of a contract and the federal money that came in the door to exclusively or to some degree help pay for it, you have to acknowledge that. After an award, well, it doesn't matter anymore. Bid bond, yes?
It may have been back in generic, pre-bid, the bid proposal affidavit.
I think that's coming up. Bid bond information. Bid bond only applies to the date of award. So you only need to worry about a bid bond until you have an award. After an award, a bid bond no longer is in effect. All right. So what did you say now?
Bid proposal affidavit.
All right. I will have to see whether that's something that has to be submitted that is true. I'll have to see if I have that in there or what I have. I think a number of these things I do have.
And then the recent BPW comments.
About the bid proposal affidavit, the fact that they want it to be changed and they want it to be approved by the Procurement Advisory Council in November. That information, I don't know anything about it. Board of Public Works, there was the last two board meetings, there have been a contested situation where the State Highway Administration wanted to award a contract to do the maintenance and upkeep of the rest stop on 95 in Howard County. And they wanted to make an award to a vendor, and the incumbent vendor, who was underbid by more than $400,000, protested the award to the vendor that Highway Administration wanted to award to. And, well, they didn't protest. That's the whole issue. They did not file a protest. Or did they file a protest? They either did or did not file a protest.
That's a question mark, right?
Yes. I'm trying to remember because it was kind of contorted, and since it wasn't on my agenda, all I knew was what I was listening to. And I think the vendor, the incumbent, did not file a protest, but even though they didn't file a protest, they wrote letters to the Board of Public Works, and they sent their lawyer to the Board of Public Works to encourage the board not to approve the recommended award by Highway Administration, even though they didn't protest it. Because you would think, well, you protest, and then you have your protest adjudicated at the Board of Contract Appeals, so they didn't do that, but they took what I sometimes call the higher route. They appealed directly to the Board of Public Works. So anyway, to make a long story short, that after the second meeting, the Board of Public Works refused to make the award that the Highway Administration wanted, and they told the Highway Administration to go back out and procure the services again, because the whole issue was that the vendor who was the lowest bidder did not exist as a vendor at the time they submitted their bid. And the time they signed their bid proposal affidavit, they were not incorporated. That what they said is, so many words, if we win this contract, we will incorporate. At this point, we have the notion, we know who's going to own this corporation, who's going to be officials, et cetera, and we have all the preparation done, but we're not going to go forward and execute unless we win the contract, unless there's a reason to do so. And when they signed the bid proposal affidavit, depending upon how literally you interpret the section that says that they are attesting, affirming that they are registered to do business in Maryland in accordance with the Corporations and Associations article of the Annotated Code of Maryland. And so does that mean they are currently registered, or does that mean they affirm that they are registered as required, but it doesn't really require me to be registered? If you don't follow that, that's understandable, because that was part of the confusion. What is the affidavit requiring? And the lawyer for the non-protesting incumbent argued that the low bidder was, and I guess I have to be guarded with my language, because he said, I never said he lied, because when he was accused of accusing the low bidder of lying in the affidavit, he said, no, I did not say they lied. I just said they affirmed to information that they could not affirm to. But I didn't say they lied. In other words, he said they're saying they are registered to do business and they're in good standing when they don't exist. And the attorneys, the principal counsel for the Highway Administration, went up to the podium and said, here are the court precedents that say that's fine, that's okay. We have done this many times. It's common business practice, especially for large construction contracts, for joint ventures to not actually incorporate unless they win a contract. So we're just doing what we've done many times. The Board of Public Works didn't like that. And despite the fact there are legal precedents where the Board of Contract Appeals has ruled that is okay. So what they said is, okay, the failure here, without saying who lied or who didn't lie or anything else, is that our form does not permit somebody to attest or not attest, or wait a minute, I don't exist yet. And so they said the answer is, we'll have a new form, and in the meantime, Highway Administration, you're going to do a new procurement so that we can get a correct information on the new form, which we will have by November. You got all that? Okay, good. So I guess in November we'll have it, even though I haven't seen it yet.
I did want to add one little.
Okay.
Presently, Highway Administration is getting the work done with their own people. So if I were on the board being presented with a new contract, I would say what, and they want, let's say $1 million for the vendor, what did it cost you to do this work with state employees? And what happened to the work they were supposedly hired for while they were cleaning trash around the rest stop? But
Okay.
we'll see.
They only have so many employees, and they can only, you're right, if they're spending the time cleaning the rest stop in Howard County, they're not doing other things. And the one thing I focused on is $470,000 or $80,000 lower in price. So they did not want to continue with the incumbent vendor, who was the one who had not protested but had complained. And so they said, instead of rewarding you for making the accusations and basically holding this up, we're just going to do it ourselves. So at least the vendor from that standpoint didn't make out, although he did win by the fact it's going to be recompeted, and now he's going to have the second opportunity to bid, knowing what the other vendor already bid the first time, which means the first vendor is now at a competitive disadvantage because everyone knows he's the number to beat. But it is what it is. Okay, post-award detail. Informational requirements that will prevail for part or all of the duration of the contract that must be known to vendors so they can include compliance in their price. Bonds. Not bid bond, because a bid bond is before the award. Performance bonds, payments bonds, fidelity bonds, those type of bonds must be identified so a vendor knows that they will price them out in their submission. Insurance. Do we require $5 million worth of insurance? Do we have to have the state as an additional co-insured? Got to know that so the vendor can go and make arrangements to get the insurance and everything else. MBE goal. They have to know what the MBE goal is because they're going to have that monitored for the duration of the contract. So they have to know, they have to include it in their price. Now, if you note, these are not things that are deliverables per se. We don't do a procurement to get a performance bond. And we don't do a procurement to get insurance. These are safeguards that are ancillary factors for the vendor to, while they're performing. But they're safeguards for the state, and the MBE is the goal of the state. Let's see. The identity of and contact information for the procurement officer, typically including that this should be the only point of contact. So they need to know that the procurement officer is the point of contact for questions, etc., and is the vendor that is the entity, the individual, that is going to continue for the life of the contract because only the procurement officer can approve modifications, terminations, officially exercise renewal options, things of that nature. Identity of contract manager. The contract type. Not the procurement type, the contract type. Because the contract type will identify the rules for payment after award. Contract duration, you got to know start, stop, etc., what the circumstances are that will identify start, stop, start, etc. Renewal options, got to know all these things. The billing payment information, how they can bill, how they will be paid, in terms of the frequency, when they will be paid, progress payments, billable expenses. All that information has to be in the solicitation so they know what to include in their pricing. Will there be any price escalation factors, consumer price index, or some type of an indice, a general indicator, etc.? Are there going to be incentives? Have to know that. Are there going to be liquidated damages? Have to know that. Various clauses on such things as conflict of interest. Conflict of interest means that the vendor is supposed to serve the state. They are supposed to owe a duty of what's called fiduciary responsibility to the state. So you might have heard the statement, you can only serve one master. You can't serve the state and also seek to serve somebody else. You can only serve one best interest. And so we don't want a vendor that's going to come into this that has some kind of conflict that they potentially will want to serve somebody else and will benefit more by serving somebody else than by serving the state. So if you're a consultant, we don't want you to come and give us advice to do something for somebody else that's paying you to basically recommend that the state go to that other entity. We don't want a conflict. And if there is a conflict, we should address what's going to happen. They could be recused, we could have a secondary vendor that we will use in those instances, that type of thing. Non-disclosure of state information. They cannot disclose any confidential information we provide to them for them to use in the execution of the contract. We may give them all kind of information about the residents of our facilities, or about medical assistance recipients, or people receiving mental health services, etc. They may need that to be able to provide services to help these people. They cannot go out and sell it, they cannot divulge it, so that is enforceable for the full duration of the contract. They can't make false statements. They can't lie, they can't say something that they know to be false, not true, etc., because there are penalties for that. And I use the word penalty because that is an aspect of tort law, and so there can be penalties for that type of thing. It's not contract law. Retention of records. We've talked about the fact they have to retain for at least 3 years. They have to be registered to do business in Maryland. They have to be registered with eMaryland Marketplace. We're giving these details. We typically have a clause, depending on the circumstances, of a substitution of personnel. They can't do a bait and switch. They can't win a contract because they identify someone with the greatest credentials in the world, and then as soon as they win the contract, well, I just transferred him to something else, some other project. Here, you're getting this person who started with the company yesterday. You can't do that because we have a clause that says you have to have our approval and they have to be someone with comparable skills, education, etc. Living wage. They have to agree. They will pay the living wage if it is applicable for living wage. They have to agree to provide payroll records to the Department of Labor Licensing and Regulation. That's for the duration of the contract. They have to know that's a requirement. Prompt payment of subcontractors. They have to know they're required to do that if they have subcontractors. They have to know if they are required to be paid electronically. That's the controller's office. So that they're going to be paid through electronic funds transfer. They have to know that. There's prohibitions on the things they can or cannot do during the duration of the contract. They cannot discriminate. These are all things that will abide by for the duration of the contract. Yes?
If somebody quits or something that they have no control over, they're personnel, then what do you do?
You don't allow a person to quit.
Yeah. Their job, right?
We have, and it should be in here, what we typically use as the substitution of personnel clause, and includes situations like that, both the anticipated and the unanticipated. And the unanticipated can be actually someone leaving, or they put their 2 weeks notice in and you can't keep someone from leaving, or it can be something like they got hit by the proverbial bus. And so they haven't left, but they're going to be incapacitated for a month or something like that. So you can have in there, and we do have in there, that if someone is simply unavailable, what the vendor has to do as a substitution for that person. So you can run the gamut, and we have the clause in there. Somewhere in this slides to go yet. Let's see. So those are what I call administrative detail, and those are examples. And they're important. They're not the same as a deliverable, but they're important because many of them impact price, and some of them impact excuse me, whether we're even going to entertain a vendor's bid. If they don't get the bid or proposal in by the due date, they've wasted their time and effort because we're not going to open it. So it's detail, but it's necessary detail. Any questions before I go to scope of work? Anyone still awake? All right, at least some people laughed. That meant at least you heard what I said. And those of you who didn't, I know who you are. All right, scope of work. This is why the procurement is being done, to achieve what is in this section of the solicitation, often referred to by various other names. Statement of work. And scope of work and statement of work are both SOWs, SOWs. Work requirements, contract requirements, deliverables, specifications. Excuse me, I've seen various solicitations that will have this section called all of these things. The most typical one is the scope of work, but it doesn't really matter as long as you have what is to be done in one discrete section. Scope of work addresses the who, what, when, where, and maybe the how of the work obligation of both parties to the contract. Both what the vendor is supposed to do and what you, the state, basically pledge or affirm that you will do to assist the vendor with what they are required to do. The activities the contractor must perform in order to earn payment. This is what they do to get the money. The other things they're not getting paid for. They're not getting paid for living wage affidavits. They're not getting paid for prompt payment of contractors. Deliverables are what they're going to get paid if they achieve. In addition to what must be done include when. Already said that. Especially the required quality level. If it is something that can be done to different degrees, what degree do we say is going to be sufficient to merit payment? And if they don't achieve that level of quality, they don't get payment, or they get a reduced level of payment. Maybe how certain aspects are to be done. The criteria that will determine whether the work has been done properly. So that ties into the quality level. If you have a quality level, you have to have some measurement as to whether that quality level has been achieved. Excuse me. Acceptance criteria as described under performance-based contracting and as will be described later under performance monitoring. Scope of work. Here are other things that most people don't think of these as necessarily being scope of work, but they are. And maybe the contractor is not paid specifically for these activities, but they have to know they have to do these activities, and if they don't, it will have an impact on what they will be paid. So, do they have to attend meetings? Do they have to provide reports? Do they have to make presentations? Do they have to do surveys? These are things they have to be aware of. They must be described. Pricing is a major aspect of the scope of work, because a vendor always wants to know, it's going to usually quote how much it's going to be paid, but the other thing they want to know is when are they going to be paid, and how much are they going to be paid at what point in time. So that needs to be discussed. We have a class that we did a pilot on either last, I think probably December. It's 540 or 50 slides, and we had difficulty getting through it in 3 days. So it may end up being a 4-day class. We may end up doing something. I haven't done anything with it since the pilot, but we have a class that all it talks about is pricing, billing, and contract type. So that's a future coming attraction. Optional activities can be included. Optional activities. They are ones that will be done at the unilateral option of the state, just as we described this morning. To be a true option, the price to perform the option activity must be provided, and I need to change that from as described earlier. That's correct. This will allow vendors' capability to perform the activity to be part of the award determination. I want to emphasize that. The fact that you identify an option, one or more options of what you can ask the vendor to do during the term of the contract, means that if it's an evaluated procurement, or even if it's sealed bidding, where you're simply making a responsibility determination, you can use their capability to be able to perform that optional activity as part of your determination. Maybe they can do the base core activities, fine, but you don't think they can do the thing that you have said that you have the option to do. And if you can't consider it, they might win something even though they don't have the capability to do something you might want them to do later, which means effectively they have not submitted to what you want to have the ability to choose among. So you want to make sure you describe it so that you can evaluate whether they can do it. Here's something that I have done at times. I've talked about what an option is. An option must specifically identify in all material aspects what a vendor is to do during the term of the option and the price. Sometimes you don't know everything you're going to want a vendor to do, or sometimes you can't get a finite price for what you might want them to do. And so you have two options. You just don't mention anything, or you have the option, what is up here, that you can, in your specifications, say that we can possibly do this in the future. And so what you can do is write in the provision that the state, under the following circumstances, the state will negotiate with the vendor to modify the contract to perform this activity, do this activity, whatever the circumstance is. And the reason why it makes sense to, in some occasions, talk about what you specifically anticipate you might do to modify a contract is it gets around the prohibition, which I guess is on the next slide, that's right here. You can only modify a contract within the scope of the contract. Once you specifically say, we're thinking about modifying the contract to do a specific activity, you are saying that activity is within the scope of the contract. So you are setting yourself up that you have the ability to modify to do that activity. Sometimes if you don't say it, it might be construed by a control agency, one that we all know and love, or the Board of Public Works, or your lawyers even, that what you want to do is outside the scope, and if there's a determination that's outside the scope, you can't do it. Now, modification means you negotiate, you have to come to typically mutual agreement, but at least you're anticipating it, so it's within the scope, and again, you can evaluate the vendor's capability in that aspect. So maybe you'll do it, maybe you won't do it, but you can evaluate whether the vendor seemingly has the capability to do this thing. You may go to them for a modification in the future. So these are just some suggestions of things to do, to think about. You want, in your solicitation, you have to have the basis for award. How are you going to decide which vendor or which vendors are going to win? And there's two aspects you want to focus on. You're going to focus on, first, I meant to hit this button, procurement method. Procurement method is going to tell you, if it's sealed bidding, the award basis is going to be the lowest price from a vendor that has a responsive bid and is responsible. But you know it is the lowest price from a responsible vendor. That is your selection criteria. If it's sealed proposals, it is most advantageous offer, considering technical and financial components. And then you have to go a little beyond that, but at least you're setting up the difference between low bid only versus combination of technical and financial offering. So that's the first element you're looking at. The second element is how many awards are you going to make? Most procurements only result in one award, but there are procurements that result in multiple awards. And if you have multiple awards, you have to say how you're going to select the multiple vendors and how usage will be apportioned among the vendors, how you're going to use those multiple vendors. And we have that later in this class about how the whole issue of multiple awards. Then you have your standard boilerplate, and these are just your mandatory clauses, most of them in 210508 and 210701. And lots of times you will have generic clauses that are not required by regulation or law, but they're ones we put in there routinely because they seem to make sense. So they are prudent. So that's basically what you have for standard boilerplate. And attachments. So here is what Gary was asking about. Typically, the contract will be an attachment. That the RFP or the IFB is not by itself a contract. As we will go through in the perform class, there's what's called invitation, bid, and acceptance. That someone makes an offer to somebody, someone else can accept that offer, and upon the acceptance of the offer, then there's a contract. And in our instance, we invite or request. We invite bids, we request proposals. In other words, we are inviting the vendor community to make us offers. And in them making us an offer, we have the right to accept that offer. If we accept it, then we have a contractual situation. So the contract is what perfects that invitation and acceptance environment. Bid proposal affidavit, contract affidavit, the price forms, electronic funds transfer form, etc. These are attachments that you will have typically in virtually any procurement that's not a small procurement. Required in certain circumstances. Yes, I'm getting tired also. As you can see, we're moving through these a little more quickly than we did the first 3 days. And I know you're just loving it because it's so exciting. It's like, okay, he's droning on and on and on. You can say it. I know, I'm droning on and on and on. All right, required in certain circumstances, still talking about attachments and exhibits. MBE forms. Well, it's only required when you have an MBE goal. If you don't have an MBE goal, it's not required. Living wage. If it is a service contract, living wage instructions and affidavit are required. If it is not a service contract, they're not required.
Is there a dollar limit?
Dollar limit. It is required for every if it's a services procurement, it is required for every contract over $100,000. Now, typically, you will not necessarily know whether your contract's going to exceed $100,000. So the general recommendation is you don't put it in any small procurement, but you put it in any procurement that is not a small procurement. And then the instructions tell a vendor, if your bid price, which supposedly they will know, is more than $100,000, it applies to you. Well, it applies to you if other circumstances apply to you. But if other circumstances don't apply, even if it's over $100,000, it may not apply. If you were confused, that's good. I could go on, but you don't want me to go on. I know that. Bond forms. If it is a performance bond, if it's a payment bond, if it's a fiduciary bond, they have to know the manner in which those bonds are to be submitted. So there will be attachments that will have the actual bonds that the vendors must submit, or they have to get the approval to use something that the state will accept that is relatively equivalent to those examples that are included as attachments. Something as simple as, we want to know whether you plan to attend the pre-bid conference. So that's typically an attachment. It doesn't mean they have to return it, that if they don't return it, they can't show up. It's just something we typically enclose so we get an idea of who's going to come. We have to know whether the site we have identified is too small or some other consideration. Conflict of interest form. If it seems to be a situation where there might be vendors with conflict of interest, we want them to return the form that says they do not have a conflict of interest. So we at least have them affirming there is no conflict of interest. So if they win the contract and ultimately it's determined there was a conflict of interest, then they made a false statement and they can be sued for a $20,000 fine, 5 years imprisonment, or both, if it gets to that extent. Non-disclosure of state information. We've talked about that, and if we want them to affirm they will not disclose information, we want them to affirm it. with the health contracts that we procure for all of you. The vendors are going to have your health data. They're going to pay claims for you. They are not permitted to disclose any of that information. They have to specifically give us an affirmation that they will not disclose that information, subject to penalties and other information if they do disclose that information. So they're not supposed to do it. Mercury affidavit, and I know all of you are looking for the Mercury affidavit, except you say, well, they don't make Mercuries anymore. That's a joke.
Very good joke.
Yeah, okay. At least some of you are still awake. If there's the potential that what you are purchasing may include mercury, then the vendor is required to give, in fact, we talked about this second day, I think, that they have to affirm either that their product does not include mercury, or they have to say the percentage of mercury contained in their product, etc. So if it's something where mercury is present, you need a mercury affidavit. Certain federal funding requirements, and this should sound familiar here. We've already talked about the lobbying, well, no, we haven't. Lobbying prohibition, that if, again, there's a lot of federal funding, that the vendor has to return a form that says that they will not do any lobbying of the federal government, including the U.S. Congress, with any monies that are derived from the contract, and they have to certify that they don't allow smoking or something like that, smoking prohibition. I know with AIDS and with mental hygiene in various places you have these attachments because they're required. And frequently you will have other attachments that are none of these but just provide information the vendor needs to know to help with their response. So that's what we advocate as the general structure of your solicitations. Are you all still with me? Am I still with me? Will my voice hold out till 4:30? 4 o'clock. See, I said it before you did, but I heard you saying it. Say 4 o'clock, 4:30 in your dreams. You said 4 o'clock, we're going to hold you to it. Someone's trying to do me better, what, 3:30? No, don't want to hear it. You contractually are obligated to be here till 4 o'clock. And then the renewal option expires. All right, price form information. These are things that you should ask for on a price form. And we will go into this in much greater detail in the pricing class, but here's just generic. You're going to want to identify the solicitation, what the price form is attached to, what it pertains to. So you have this on the actual page that vendors are pricing and signing, so if it gets separated, you still know what it applies to. Page numbers. If you have a 5-page price form, you will want, let's say it's attachment B, B1, B2, B3, B4, etc. So you can have pages. Or just number it consecutively in the entire solicitation. It can be pages 84 through 88. But you will have separate identification of each page. A price line for each and every item that will be used to determine the award, including subtotals and totals when appropriate. We go over this in great detail in the pricing class. Each and every item that will be used to determine the award, you need a price line for those. It's generic at this point in pricing. We don't have it generic. We have example after example of actual procurements, and we translate this to real situations. You want a signature line, name of the vendor, date, signer's title, signer's printed name. So somebody is attesting that that is the price that they are submitting to the state. And you can hold them to it by the fact they are signing and they're saying they are in a position of authority for the vendor. Tax identification number, or the Social Security number if it's an individual. For an indefinite quantity contract with the evaluated price, include a statement that indicates the quantities listed on the price sheet will be used for evaluation purposes only. They are not guaranteed minimum or maximum quantities to be obtained, and the state will only pay for actual usage at the quoted unit prices. You will have generic language that will say that. so that a vendor can't come back and say, wait a minute, in your model, you said you were going to buy 100 of these, you've only bought 20, you owe me the purchase of 80 more. Nope, we didn't commit to any certain quantity. All we said is the price is firm with however many we actually buy, depending upon whether any of the circumstances in future slides are going to be the case. All right, any questions on that? Now I'm going to quickly fly through about 4 slides because we're going to talk about these individually. All right, let's see. Where are we going? Okay. Solicitation clauses, mandatory for all solicitations, all other than small procurement. Public Information Act notice. You're going to make sure your solicitation includes that. Minority Business Enterprise Notice. Regardless of whether you have an MBE goal, you're going to have a generic statement that says minority business enterprises are encouraged to respond to this solicitation notice. That's a mandatory clause, regardless of whether you have a goal. Arrearages. The vendor affirms it is not in arrearage in pay of any taxes or information due to the state of Maryland, and affirms that it will not become so in arrears during the course of this contract. So it's a mandatory clause. Bid proposal affidavit is mandatory for all above small procurement. Cancellation. State reserves the right to cancel this solicitation in whole or in part without liability to the vendor. Rejection of individual bidder proposal. We have the right to reject any or all proposals submitted in response to this solicitation. Electronic fund transfer. You're going to have that in there, that the Controller's Office will pay you by electronic fund transfer. Mandatory for some, and this is to a degree repetitive, a bid bond notice if you're requiring a bid bond. An MBE goal, the forms, etc., if you have an MBE goal. Vendor requirements when an MBE goal has been identified. Non-visual access. If it is information technology, hardware, or software, you're going to have the non-visual access clause. If you require bonds, you're going to have a clause talking about MSBIFA. That is the Maryland Small Business something, something, something as part of the Department of Business and Economic Development, and vendors who can't get bonding through regular commercial market can go to Business and Economic Development and try and get bonding through that department. So you're supposed to let them know about the ability to go and get that bonding assistance if they can't get it in the commercial market. Yes?
This information, would that be under the administrative details category? Or are you making this a separate, almost a separate boilerplate type thing?
At this point, we're not segmenting it into which of those aspects it is. We're just saying these are the type of things that you have to have in there. Some of them at all times, other times, some of the times. And it can be,
which ones.
Yeah, these probably are going to be probably post-award information.
That might be true. I hadn't thought about that.
This is stuff that generally is going to survive the award of the contract. I don't think I thought about it in that context, but I probably should have. So I'm thinking offhand that's what it probably is. Small business preference, well, here we have an exception. Small business preference only applies up to the award point, and then it doesn't apply again. So that's a pre-award detail. And we talked about that, I guess, on the second day or the third day. We talked about reciprocal preference, the Department of Human Resources hiring agreement. We talked about that under socioeconomic. Discussions. If you're doing sealed proposal, you're going to have a generic clause relative to discussions, that vendors will typically have oral presentations, et cetera, et cetera. If it's sealed proposal, you're going to have a mandatory clause dealing with alternate and multiple proposals. Again, the conflict of interest disclosure, living wage affidavit, mercury content, prompt payment, if they apply. Suggested. Communications, that's Who do you contact for questions and things like that? Protest requirements. If they're going to protest, which we hope they don't, but what governs protest? Period of irrevocability, and this is an important consideration, although I think I have discussed it later. How long must their bid or proposal be firm? I.e., how long does the state have the right to accept their bid or proposal and they cannot rescind it? And generally, a lot of you will recognize this as being typically either 60 or 90 days. But if you're doing a major sealed proposal procurement, we recommend typically 120 days, and in some circumstances more than that. In fact, there's, due to a state law that was changed in the past 2 years that affects the Department of Human Resources and Department of Juvenile Services, before they can open a new facility for residential child placement, they have to issue I think it's a certificate of need, and the certificate of need has to be submitted to the Office of Children, which is over in 301 West Preston. And the Office of Children has to have, by law, 60 days to review that certificate of need. And then they have up to 30 additional days to ask questions of the vendors, for the vendors to come in and give them additional information for Office of Children to determine whether they should issue a certificate of need or whatever this is called. So there's 90 days, and the proposal doesn't go to DHR or Juvenile Services. The proposal goes directly to Office of Children. And it's 90 days at a minimum before either Human Resources or Juvenile Services can even get the proposals. And so we have advised them that they're probably looking at a minimum of 180 days for irrevocability because of this new structure that is superimposed upon the state procurement process. Just be thankful you don't have to worry about it. Let's see, so irrevocability, and we'll deal with that a little more in the class. Conditioning of bids, you tell them they cannot condition their bid. They cannot say their price is only valid if they get some other contract or some other circumstance occurs. And if those don't occur, their price isn't good. They can't say that unless we have allowed and specifically structured a situation. For instance, I did a procurement relatively recently that had 3 functional areas, and vendors could respond to either 1, 2, or 3, or any combination of 2, 3, 1, whatever, all of them, one of them. But we allowed that if they received more than one award, they could give us a discount off their quoted price. So that if we awarded them areas 2 and 3, and they had said they would give a 5% discount to their individual prices if they got both awards, then we would take their discounted price as the basis to decide if they would win. So because we structured it that way, that is a condition that we are allowing and in fact encouraging. But if we didn't structure it that way, they can't say, oh, our price is only good if we get functional areas 2 and 3. If it's sealed bidding, you should have a clause that deals with ties. That's a mandatory clause, but also I may have mentioned that you can structure an additional tie-breaking mechanism if you think the existing tie-breaking mechanism in 210502, I believe 14, doesn't break the tie. Electronic procurements is what you were handed out by Gary before this afternoon class. And we have that in a couple slides, but this is what is now interpreted is necessary to tell vendors specifically which aspects of both the procurement and contract management can be conducted by electronic means, which generally means email. And the interpretation is that under existing procurement regulations and law, if you do not in your solicitation identify what aspects can be submitted at the very least by email, then everything has to be by regular mail, the proverbial snail mail. And most of us would never think of that. You don't think, well, an email or having the MVE reports submitted electronically or having bills electronically is any problem, but supposedly, unless you specifically allow it, you can't do it. So this is the language we now use, and it's been modified as recently as a month ago. So this is the very latest version. So it is recommended. Now the version you have here refers to DBM. And actually the law structures this in two ways. One for primary procurement units, of which there are 10, and neither environment nor DHMH is a primary procurement unit. So you cannot use that language exactly as per this example. What you have to do, and I'll say it to Gary. Now, Gary, what you have to do, it'll be on the recording so Gary can go and see what he has to do. Plus, you'll tell him. Your attorney has to determine to what degree this needs to be modified for you to use it. It doesn't require a lot of modification, but it requires some minor degree of modification because for an agency other than a primary procurement unit to be able to do these things electronically. So just know that that is a consideration. How vendors are going to acknowledge amendments to the specifications, and again, e-mail marketplace registration. Suggested clauses. Come on, 2:30. Inform vendors, the response instructions, and sometimes these are very important. They're very important when they don't come in correctly and you can't rely upon a vendor to have affirmatively submitted a bid of proposal or to even know who submitted something. So inform vendors of the minimum number and type of references and reference identification information, and we're going to discuss this later. That responses should be printed, typewritten, or legibly written in ink. That all erasures or alterations should be initialed by the signer in ink and dated, and that all signatures should be written in ink. So this is stuff you should be informing them. Inform vendors that responses should be submitted in a sealed envelope that clearly indicates, number one, that it contains a response to a solicitation. Number two, the solicitation identification. Number three, the name and address of the submitting vendor. And you can even go so far as to say, and put contact information on the outside envelope. Because I think I mentioned in the Procure class, we went through some examples, those of you who took that. And we talked about the situation where a proposal, a bid, whatever it was submitted to the wrong location. I think one was submitted to Annapolis, an example I gave, and it was due in Baltimore, or else it was submitted to Baltimore and due in Annapolis. I don't remember which one. Because we could identify on the outside of the envelope what company submitted it, and in that particular instance, we had, as on our contact information, who the contact person was for that vendor. We were able to, and this happened about 2 hours before the due date, we were able to call the vendor up, tell them they had submitted it to the wrong place, and tell them they had 2 hours to come get it and deliver it to the right place by the right time. If they would not have had that information of who they were on the outside, we would have had, our only choice would have been to open it, the thing you're not supposed to open before the due date, to find out who it was to potentially notify, or just sit there and say, oh well, it's not where it's supposed to be. I don't know who it is. I can't do anything about it. Simple information like that on the outside of the envelope can help in certain circumstances if they messed up to begin with. Okay, well, let us take a break before we get to these wonderful other issues. So come back in about 15.